Good afternoon. Thank you for clicking on this video for the Commercial Receiver Association, and you can link to this and other videos at commercialreceiver.org. Today, we're going to be talking about receivership in the state courts in Missouri. And Missouri is unique in that it has a fairly extensive new statute. And to talk about that and how receiverships operate in Missouri, with me today is Brian Hockett. Brian is a partner with Thompson, Coburn. He was instrumental in crafting the Missouri Commercial Receivership Act, which became law in Missouri in 2016. The MCRA provides a comprehensive receivership process to promote efficiency and predictability of receivership proceedings in Missouri. He's also the past chair of the Missouri Bar Bankruptcy Creditor and Debtor Rights Committee, and he chairs the Bankruptcy Practice Memorial Fund. He's a frequent writer and panelist on presentations regarding insolvency law, receivership, and bankruptcy. And a link to Mr. Hockett's biography can be found at the CRA website at the Missouri tab at commercialreceiver.org. So thank you so much, Brian, for joining and agreeing to go through how receivership works in Missouri. And I guess what I'd start with is, from a high level perspective, how does a commercial receivership start in Missouri, and what are the required filings to initiate that kind of a process?
Sure. So in Missouri, a commercial receivership can be ancillary to another action. So you could have another action going and then have a receivership filed, requested through motion, but it also could be filed as a separate action on its own, and simply be an action petition in Missouri State Court is filed, and you could file a petition for the appointment of a receivership. So it could actually be filed in either manner.
So in some states, they divide up receivership processes. In Rhode Island, they have one type of receivership deals with insolvency, and that's a liquidating receivership, whereas another type of receivership is more of a maintenance of an ongoing business, and they regard that as an equity receivership. Other states divide things up differently. Does Missouri distinguish between different types of a commercial receivership?
So it does to some extent, although I will say that the Missouri Commercial Receivership Act, or the MCRA, I'll probably abbreviate it that way as we're talking, is a fairly comprehensive and is intended to cover the gamut, whether it's a liquidation or intended to be more of an operating type of receivership. The way that the Missouri Receivership Act, the MCRA, divides things up, there are limited receiverships, which are intended to be just receiverships for specific property that need to be described in the order appointing the receiver, or a general receivership. And general receivership is probably more akin to what you were referencing in Rhode Island relating to the equity receivership. A general receivership is a receiver over all the assets, and typically they could operate a company as well, because they would be in control of, say, an entire enterprise, an entire company.
And so in a general receivership, then the receiver has a management right and can oversee, or is he superior to the president, the CEO, that type of thing?
Correct. So yeah, they would be in charge. They would essentially have the right to manage a company. That's exactly right. They would have control over an entire company, not just control over a specific asset. Correct.
So who gets to bring a receivership action under the MCRA?
Well, so the MCRA, so who gets to bring a receivership up? So the MCRA is a little vague on that issue, which has resulted in, actually, at least in 2 instances that I know of, in which, that's not true. I think there's 3 instances now where a target entity would be, the target of the receivership, actually filed a receivership action against themselves to have a receiver appointed. Those have stood up to at least scrutiny at the circuit court. That's the trial level court. I don't know that anybody's appealed that issue up, whether somebody can actually file an action against themselves to have a receivership appointed. But so far, that's happened in 3 instances that I can think of in the state of Missouri. Typically, though, you're going to have a receivership filed by a creditor. I mean, that's the usual use of it. Somebody that has usually pretty much in almost 90% of the instances, 99% of the instances, it's going to be a secured creditor that has an interest in the assets, usually all assets of the company, and they want to make sure that the company can be sold under controlled circumstance as a going concern. So you get a general receivership appointed to, make sure that the enterprise value isn't lost in just a foreclosure. It could also be filed in certain instances, say where there's a dispute among management. It could also be filed post judgment if you have a judgment against an entity and you needed to get control of that company in order to maximize your recovery on a judgment. So I mean, those would be the typical instances, but I think in most cases it's going to be filed by a secured creditor.
And this is a little bit off topic, and I don't know if you were involved in any of those cases, but and you're free to speculate. Why would a company file a receivership against itself?
Okay, so somebody might file a receivership against themselves in a couple instances. The one instance where I saw it, it was actually intended to help to control an aggressive judgment creditor that was chasing them. And I think, frankly, from their perspective, asking the court for the appointment of a receiver was a more palatable result than filing for bankruptcy. I think they probably felt like it would be a less public affair than a bankruptcy would. In another instance, the particular institution was an educational institution, and if an educational institution like a higher education, so like a trade school or something like that, files for bankruptcy under the bankruptcy code, they're no longer eligible for subsidized loans from the federal government, which would be a death knell. So they needed a liquidation or a platform from which they could sell, but they couldn't risk losing the federal subsidized loan programs that are their lifeblood. So that was an instance where it was kind of like, we need a vehicle, but it can't be bankruptcy. And
receivership serve to kind of preserve the value where otherwise the alternative would have meant a collapse.
Correct. That's exactly right. I mean, it would have been, the value would have been lost. The schools would have simply shut down instead of being sold. It would have, I don't know that it would have served anybody, including the students, well in that instance, frankly.
All right. So getting back to kind of a more general topic. So a receiver, let's say you go in and you get a general receiver appointed. That person is someone who is selected by the plaintiff, proposed by the defendant. Is it a joint decision? Is there a panel of receivers from whom the court selects? How does that work?
So again, that is something. So as comprehensive as the MCRA, it doesn't tell you exactly how to pick a receiver. Usually, the person requesting the receiver is gonna have somebody in mind, and they will ask the court to appoint that person. Usually, the person who is asking for the receivership does have the protection of the assets in mind, so their choice is going to be guided by that. The court can honestly pick anybody that it wanted to. There are limits within the MCRA regarding potential conflicts that the receiver might have. I'd have to look back to see what that is. I don't off the top of my head. It would be something, it couldn't be an employee of the person requesting the receiver. And there are other limitations. I off the top of my head, Eric, I can't remember, but there are some limitations on who it could be. It can't just be anybody, but
Right.
The judge could select somebody other than who's suggested by the person requesting the receivership appointment.
Okay, so you get a receiver, maybe it's an attorney, an accountant, a professional of some other type, a turnaround professional,
Sure.
and they're appointed. What's their next step? Do they send out notices? Do they advise people who otherwise may not have known about the case that their rights are being adjudicated? What's their next step?
Sure. So in Missouri, notices are certainly a requirement in the appointment of a receiver. So the goal of the MCRA was not just to provide the receiver with some more robust tools to use, but it was also to make sure that at least minimum due process was provided to people that might have an interest in the assets that were put in the receivership. So the debtor, the target of the receivership, much like in the context of a bankruptcy filing, is required to cooperate to some extent and provide access to books and records. And then they're supposed to provide essentially schedules of their creditors. And all of those known creditors are supposed to get mailed a notice by the receiver within a fairly short period of time. I want to say it's 10 days. I can't remember the exact timing, but it's a fairly short period of time. The receiver is supposed to get out a notice to known creditors, and the form of the notice. There's not a specific form of the notice, but the contents of that notice are spelled out, and the contents are spelled out. In addition, the receiver is supposed to a general receiver, at least, is supposed to publish in a newspaper. If there's real estate involved, the receiver should certainly file, and I think they're required to file a lis pendens in the county real estate records. So notices are provided essentially to get everybody noticed that, hey, this receivership has been filed, and if you have an interest, draw near and make your claim be known. Yep.
So sounds like there's a lot of activity, and you've referenced the statute. What are the appointment orders typically look like? Or is there a form that the court provides? How does the appointment order kind of usually function in a Missouri receivership?
Sure. So prior to the Missouri Commercial Receivership Act, essentially all the powers of the receiver would be spelled out in an order appointing a receiver. One of the goals of the MCRA was to have a more comprehensive list. Hey, here's the powers that receivers have. That being said, even since the enactment of that statute, I've not seen a short order appointing a receiver. Typically, the powers, whether they need to be explained or supplemented or limited, they're all going to be spelled out in the receivership order. I think that the receivership statute itself does provide a backbone, so that there is certain powers that are there, whether they're in the order or not. But most people that are drafting these orders are still putting together pretty comprehensive orders. Whether they'll ever get to trusting that the statute will satisfy them, I don't know. All lawyers think that they can improve, so I think most lawyers will want to spell out the powers in their own order that they draft. So that's what I suspect will continue happening.
And so if that's the case, I suppose it does enable lawyers who deal in this with some frequency to tailor their orders to fit a circumstance. So
yeah.
No, go ahead.
And I'm sorry to interrupt it, but what I was going to say is that's what I kind of meant about either supplementing or limiting certain powers that the receiver might have, or the expectations that the court. You have to remember, while the person requesting the order is the one that usually is drafting the order, this is the court directing the receiver what to do and what they can and can't do. So it's the court directing its agent, essentially, and that's not the right word for it. It's not an agency relationship, but the receiver is the appointed by the court, and he's the court appointed person that can do X, Y, and Z that's in the order. And if you wanted to had a special circumstances that needed additional powers or a reduced power, as long as it wasn't significantly inconsistent with protecting the assets of the estate and maximizing value for the stakeholders. Certainly, I think any judge would enter that order. It's intended to be flexible. I mean, I said that in a lot longer than I needed to, but it's intended to be flexible.
Okay. Well, so one of the things you mentioned early on, though, is that the receiver comes in, and I'm sure that the analysis has happened beforehand. Getting a receiver appointed is really not the goal. The goal is to get the receiver discharged after having completed some goal, right? Some task. A lot of times that's a sale. Can a receiver sell property? Can they sell free and clear of liens in Missouri? And if so, how does that work? And have you seen any hiccups or problems that have arisen?
Okay, so yes, a receiver can sell property in the state of Missouri. Prior to the enactment of the MCRA, the statute was not clear about the receiver's power on that, and there was always an issue about whether or not you could get a title company to sign off on, say, the sale of real estate if you didn't have the cooperation of the defendant or the target of the receivership. Now, the statute does provide for the sale of property and a procedure by which property can be sold. And I've not had any issues with any title companies signing off on it. There are some limits to that. So a general receiver can sell property free and clear of liens. A notice is provided to any interested party. I can't remember what it requires notice to all creditors again, but I think in the instance in which we sold, the most recent instance I can think of, we did send notice to all creditors again regarding the sale of property. And the sale of that property in that instance was actually farmland, which is excluded from the general powers of sale that a receiver might have. So farmland or a homestead are excluded from what a receiver can sell, unless they have the consent of the party of the target. And in that instance, we did have the consent of the owner of the real estate, and we're able to sell it through the receivership. And honestly, the process actually went very smoothly in every instance in which I've gone through it, and I've been pretty happy with it. The process does provide the ability of the debtor or an interested party coming in and objecting to the sale, at which point there could be a hearing regarding the potential value that's being gained by the receiver through the sale process. But I've not had a contested sale hearing yet. So there was a little snafu. Yeah, no, really nothing that was nothing that I would call a contested hearing regarding a sale. And title companies have not had an issue with ensuring title that I've dealt with.
So this is a comprehensive, labor-intensive process. It requires operating businesses. It requires selling property, notices. There's a lot of work that goes in there. How does a receiver get paid? Can they hire attorneys or accountants? How do they get those people paid? And how do they cover the bills in a receivership case, particularly where there's a secured creditor that has a lien on all the assets?
Yeah, so several things there. Number one, the first, they can hire professionals. Professionals do have to apply. There are certain requirements for a professional regarding disinterestedness as well, similar to the receiver's own requirements. And the professionals do have to apply to the court to be compensated, which is not going to be an unusual process for somebody that practices in the bankruptcy field. But so there are those issues around that. But the source of funds, obviously, to operate the company would first be, if they are actually operating the company, it would be, the proceeds from operating the company. If they're selling property, it would be proceeds from the sale of property. If there's a secured creditor that requested the receiver, the property could essentially be, surcharge is not quite the right word here, but if you're requesting the receivership, there's going to be, you're going to be paying the freight, frankly, and it's going to come out of your assets. Now, I suppose it is possible that you could have a receivership appointed where the secured party wasn't the requesting party for the appointment of the receiver, and at that point, funding and financing for a receivership becomes all the more important for the receiver and its professionals to make sure that there's a sufficient carve out from the proceeds for them. And that would have to be something that would be negotiated with the secured party. But obviously the source of funds are the receivership itself, and then potentially if the requesting party might have to pony up money if there's not, if the receivership just simply doesn't generate funds for those purposes.
So these are fraught processes. Frequently people are at each other's throats. It's in litigation, and the receiver kind of gets put into the middle of it. And while yes, they get paid, do they have any other protections? Because it's, I think, foreseeable that one side or the other decides that the receiver needs to be disciplined or be attacked or accused. And I've seen it happen. I'm sure you have as well. How does the statute deal with that?
Sure. So when a receiver is appointed, they're appointed under the authority of the court. I use the word agent, and I'm going to use it again, although I think agency law doesn't exactly apply here. That's not the right word, but they are a representative of the court, and there are limitations to the receiver's liability. Obviously, as long as they're acting within their authority provided for in the receivership order and the statute, then they shouldn't be held responsible for the acts that they are engaging in. Obviously, if they go outside of those acts and they're, if there are truly bad receivers, and I've not dealt with a bad self-dealing receiver that I felt was, acting not in the interest, not doing their best to act in the interests of the receivership state, there could be some personal liability there. But usually any liability the receiver has is going to be limited to the receivership itself. And there are protections in there, including if you do want to bring an action against the receiver for any perceived wrongs, you do need to go to the appointing court and get permission to do so first. So I think that being a receiver is a fairly you are dealing with people that are oftentimes angry with each other, and you are in the middle of it, and you can certainly get hit in the crossfire. But I think that there are sufficient protections in the statute that you can feel like your personal finances are secured from those attacks, as long as you're as long as you're acting within your power, you're appropriately acting within your powers.
And after the case is done, or after the receiver's discharged, do they retain that protection? Because some vengeful person might want to sue them later. Can they retain their protection after they're done?
So they do. In the discharge orders, and I'd have to look back at the statute to see what it provides regarding the discharge of a receiver. But in the discharge orders that I would want to get, it would include essentially a finding that you completed your job and you did it well, and et cetera. But the protection would continue. I mean, somebody can't come back later and claim that you did something wrong unless you did actually go outside of the statute and committed liability there. That doesn't mean somebody can't bring a lawsuit against you, because people can bring lawsuits for all sorts of things. But but in general, no, your protection is gonna continue, and you'll be discharged from the duties and the liabilities. So
Well, I'll tell you what, this has been very helpful. I think it's going to be helpful for people who get a chance to view this. If people have questions, want to follow up with you on receivership questions, they have a receivership they might want to file. We'll have a link, and everyone who watches this find Brian Hockett at the Thompson Coburn website. All of his contact information is there. Brian, greatly appreciate you taking the time to walk through the receivership process in Missouri. And we look forward to talking to you again soon.
thanks, Eric. Always a pleasure. Thank you.
Thanks.